Good morning, sir. You're John Jones.
Yes, ma'am.
And Mr. Jones has 4 cases, all on the set for trial to begin with jury selection next Monday afternoon. We have 25 DCCR 0523 charged with murder, 24 DCCR 2431 charged with unauthorized use of a vehicle, 25 DCCR 1352 charged with aggravated robbery, and 25 DCCR 1353 charged with robbery. And what is the announcement?
Judge, we're ready for trial. We just need to know which one is going first.
State's ready for trial, Judge. I believe we'll elect to try the murder first.
Okay, I will number the cases after docket today. Has there been any other discussions or negotiations? Let's see, was there an offer already rejected in the murder?
Yes, Your Honor, there was, and Mr. Coleman entertained some counter offers that he wasn't willing to take. He did make a kind of a final offer last time, so I don't think we're gonna get anywhere on.
Okay, so it looks like the last thing I have at least in writing was 35 years.
That sounds right. I can bring my file down.
Okay.
That sounds right, Judge.
And so, Mr. Jones, I want to make sure you understand, your case will be set numbered and those cases will, be put in an order this afternoon after docket. And after today, there won't be any plea agreements unless there's some new information that comes to light. If you change your mind, you can plea either open to the court or some different amount that's negotiated. Do you understand?
Judge,
And
if I'm
you're-
not mistaken, I'm sorry to interrupt.
Go
the court.
ahead.
I'm sure that the last setting, the court admonished the defendant about the possibility of accumulation. I think at least a couple of these maybe.
Yeah, so it looks like we've got three different offense dates. It looks like the ag robbery and the robbery are the same date. And then we've got that unauthorized use from October of 24, and then the murder is from April of 25. What that means, and we've probably talked about it, but just in case we didn't, is that if you go to trial, let's say you go to trial on the murder and the jury finds you guilty and you get some punishment, the state can then try aggravated robbery or the robbery. If you get a sentence on that, they can ask me to then stack those or run them consecutively. You understand that as well,
Yes,
right? Okay. And you want to go forward with your trial next week?
Yes, ma'am.
All right.
Judge, if you, I recall something now that I completely blanked out on. We had previously, talked about doing a plea on the unauthorized use and just going, the offer was two's the max, going open to the court, because the state didn't want to piecemeal it, just to get that one out of the way, Judge. If you want me to do the paperwork on that, I can.
Honestly, I think it's probably, what I don't want to do just based on the nature of that. I mean, all of those things, I guess, in punishment, whether convicted or not, could be used potentially as some types of extraneous offenses, given the proper notice. I really am okay with you not doing that. Let's just keep them all together. Let's see where we get. If it goes forward next week, potentially, then we'll kind of go from there.
Address it from there.
Yeah.
Thank
Okay,
you, Judge.
thanks. All right. I'll let you know after docket the numbers.
Okay.
For the order. And then, Mr. Wilkerson, you have a Jordan Thomas.
Yes, ma'am.
Jordan Thomas. All right, so hold on a second. Ms. French on Jordan Thomas. Yes, Your Honor. Good morning, sir. Are you Jordan Thomas?
Yes, ma'am.
And this is 24 DCCR 0487. Mr. Thomas is charged with sexual assault of a child, and 24 DCCR 2178 charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, on this one, we're gonna ask for a 45-day reset. Me and Ms. French have spoken about it, and she wants an opportunity to speak with the family. And I still need to go review the video. There's not an offer in the file that Ms. French inherited. If I remember correctly, we had an offer on the ag assault, but not the sexual assault of a child. And so if we can get just that one last reset, I think we can be 100% ready to either move it forward on trial or plea it out if that's going to be a possibility.
I guess my only concern is I typically don't do 45 days. You're not waiting on any evidence that you know of when your file DNA or anything like that.
Your Honor, the only reason we added 45 from 30 is because I am out the rest of the week from Thursday and Friday. And Mr. Wilkerson's schedule is that he's going to be in trial next week. So that takes 2 weeks off of our
Okay.
ability to look at these
Yeah,
things.
I'm not certain about trial. I've obviously got Mr. Jones in here, which I'll know more about today, but I also have a couple over in CDCs.
Right, so I'm gonna do 45 days, but I'll make that notation that this is the final reset. So,
Okay.
you guys get taken care of what you need to. We'll get an announcement one way or the other that next court date.
Yes, sir.
You
Thank
go back.
you, Your Honor.
Kayla. Thank you.
Judge.
Yes, sir. Good morning. Are you Donnie Smith?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Hello, Your Honor.
Mr. Smith, in cause number 26, DCCR 0072, you're charged with a second-degree felony offense of assault on a peace officer from December 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any type of any right to appeal?
Yes, ma'am.
And so I see it's just marked off community supervision, but nothing
So
else.
we're unagreed as to the type. The state is recommending straight probation. We're recommending deferred.
And leaving the type and the amount of time
Yes.
up to the court. So I want to make sure you understand that the agreement is that you get a probation. The type of probation, whether it's straight or deferred, will be up to me at sentencing, and also the length of time that you're on probation and any conditions, and any fine in addition to that. Do you understand?
Yes, ma'am.
And you have an absolute right to have a jury come in and determine if you're guilty or not, and you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Ms. Malfino, what is the state's position with regard to a bond reduction based on that plea?
Judge, in reviewing Mr. Coleman's notes in this case, it doesn't appear that this young defendant has any substantial criminal history, just so the court is aware of pending UCW and evading also arose out of this incident. And so it's obviously concerning to the state that a weapon was involved, but I've heard of what you think is appropriate, unless Mr. Coleman has additional to add.
Nothing to add to that. Thank you.
Thank you. All right, Mr. Smith, what I'm going to do based on the nature of your plea agreement is reduce your bond in your case to $2,000. If you make that bond, there's a couple of very important things that are going to go along with it. One, the very first thing you do is go straight to the probation department so they can start that process to get that report done for me. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be much worse. Do you understand?
Yes, ma'am.
Also, if you make that bond and you are arrested for anything between now and when you come back, you obviously run the risk of me not accepting the agreement. You understand that as well.
Yes, ma'am.
In addition, I'm going to order as a condition of that bond, you are to have absolutely no possession of any firearm. Okay.
Ma'am.
That means you can't be in a car with someone else that has a gun. You cannot be in a home where there are guns. You cannot be around any guns until further sentencing. We'll figure that out depending on what's going on with that misdemeanor case.
Yes,
Do you
ma'am.
understand? Any other conditions that?
No, Judge.
All right, then we will see you at sentencing. You can go back with the bailiff. Good morning, ma'am. Are you Angela Reyes?
Yes, ma'am.
And Ms. Reyes is charged in cause number 26 DCCR 0264 with assault on a peace officer, 26 DCCR 0265 with the obstruction or retaliation, and 26 DCCR 0266 with assault on a peace officer. Those offense dates are all from December 22nd of 2025. It looks like the cases were indicted February 11th of 2026. And so, Ms. Reyes, let me just get everything straight first. Were you released on accusation when you first got arrested on these offenses?
Yes, ma'am.
And then the indictments came down and there were warrants and you went back into custody,
Yes, ma'am.
correct? Do you, Mike can tell, but do you remember the date that you went back into custody?
I know it was Wednesday last week when they picked me up on a warrant from my
Okay,
house.
so was it? Okay. The 25th, February 25th.
Yes, ma'am.
This shows when these were executed. You were magistrated out at the jail that next morning, and it appears as though the magistrate set the bonds at $10,000 for the 2 assault on a peace officer charges and $8,000 on the obstruction charge. The district attorney's office has filed an Article 17 objection to that bond, asking that I increase the bond. Have you been arrested for anything? Well, let me do this first. Raise your right hand the best you can. You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay, so from the date of these offenses in December 22nd of 2025, have you been arrested for anything else?
Since December?
Yes,
No,
ma'am.
I have not.
Okay,
And this is my first like big I've ever,
these are your first felonies?
yes.
And Mr. Coleman, you're shaking your head. Do you agree that there's nothing in your file that shows that there's any felony criminal history?
I agree with you.
Okay. Let me do this real quick because typically this review is going to be, it's a new type of thing, a law that has been handed down for the district attorney's office and the courts to review certain bonds that the magistrate set, but typically that is going to be when you're on bond for one felony and then another felony is alleged to have been committed, which we don't have here. And so let me take a quick look at the probable cause in these cases, and then I'll let you guys kind of know where I stand on it. And Ms. Reyes, have you ever had any type of mental health um, assessments or counseling, or are there any issues that go on that you have going on that you feel like you would need that?
I will say a year ago in February, I survived a suicide attempt. So I had to get hospitalized. And that's where they did evaluations and diagnosed me with depression. Um, so I've been off my medicine because my insurance lapsed because I just had a baby in September. And I haven't been able to take it since I started getting back on it whenever I went into custody. So they set me up on that.
If you make your bond, as it's set now, or depending on what it is, where would you reside?
With my father and my 2 children at the 7515 North Major.
Okay, well, that's where you were when they came to get you and arguing with your dad. Is that correct?
It was with my fiance. It was virtual.
Okay. You were arguing with your fiance, or your fiance was arguing with your dad, or who was arguing with who?
It was me and my fiance, and then my dad was the one who called the police.
Okay. Where would your fiance be living?
He lives there too.
Okay,
also.
so here's where, at least while this is pending, there could be some issues. Well, Mr. Coleman, I guess based on where I've gone kind of so far with this, what is your position with regard to the motion that
Yes. Just,
your
we-
office
we-
filed?
We'd simply just ask that the court give the motion its due consideration, and
Okay.
certainly we defer to the discretion of the court.
Mr. Lewis?
Judge, well, I had conversations with Ms. Reyes, his father, who was there and the one who called the police. And as far as a bond goes, my conversation with him was that even the amount that is set could be a stretch for them to try to make. And also, like I said, with some of the issues that she was already having, part of that was her not being able to have her medication because it was a financial issue. So of course, we'll be asking if the bond remains as the same. But like I said, if they are able to make that bond, that would definitely be an amount that, would definitely ensure her return to court and well, any public safety issues.
All right, then here's what I'm gonna do. At this time, I'm not going to raise your bonds in your cases. I'm going to deny the state's motion to raise those bonds. I am going to make a condition of the bonds, if you make them, that you make appointment and go to the Spindletop Center for treatment, medication, assessment.
Yes, ma'am.
They will work with you without insurance. And so it's going to be a condition of your bond that you do that.
Go do
So
that.
you need to make sure if you make your bond, that when you make that appointment, you get that appointment to Mr. Lewis and your bondsman, so they know you're following through, so I know you're following
Oh.
through. And that's really just meant, if for me to order, it means that they should be able to help you more
Yeah.
because it's a court order.
Mhm.
And so there's no reason for you not to go do that. And
Yeah.
now, if you don't do it, it'd be a violation of your bond. And obviously at that point, Mr. Coleman might have more to say than he did today. And we would have some concern about some of the same behavior, and I would have no choice but to raise those bonds. Do you understand?
Yes, ma'am.
Okay, all right, you can go back with the bailiff.
All right, thanks.
Thank you.
Thanks, Jeff.